path to do something, or at least make a proposal rather than just walk away. So, over the last few weeks, I guess, we've been just having a lot of back and forth internally, trying to kind of get to a proposal that we would get support for at the committee level, and that we thought might be potentially viable for the case. When we spoke before, we were aiming, at I think like a 5.5 million funding commitment. We couldn't get support for that, at least not at this stage. And basically where it shook out is, we had support for a much smaller commitment at the 3 million level. Understanding that is significantly south of the numbers, that you guys need to adequately litigate the case on the basis of your own projections. So we've put that forward for discussion. Fully understand you guys may turn around to say, well, look, it's so far off, it's not even worth entertaining, and that's understandable. But we wanted to at least table something to try and see if there's a way forward. In terms of just how that would work, obviously we'd need to kind of figure it out in discussion with you guys in terms of how that gets allocated. But I think the bottom line would be we would fund, if with obviously with a big if that this is something that makes sense for you, we would fund, in accordance with an agreed, project plan, expenses on the same terms as the original deal. We would have the, right of first refusal to extend additional funding, if and when that funding is exhausted, but not the obligation. And if we did not extend additional funding, then we would have no responsibility to fund beyond that. And it would be essentially up to the firms to either, carry the additional expenses from that point forward or seek alternative funding. But we would need a sort of a backstop position that the firms would ultimately be responsible for seeing the case through, such that we don't find ourselves in a position that the case just kind of grinds to a halt for lack of funding, but we've already fully deployed our 3 million at that point. So, and I think in terms of how I would sort of see that playing out, I mean, again, I think we, you guys would need to be comfortable that if we decline to provide additional funding, that you can see the case through. But informally, I would think there's a reasonable likelihood if the case is shaping up well, particularly if we have, a good direction of travel on damages. I think it's likely we would want to upsize, but obviously we can't, we wouldn't be committed to that, and I wouldn't want you to rely on that in any way. You need to be comfortable as a backstop position. But I mean, I do think that, once you're invested in the case, and if it's progressing in a reasonable fashion, upsizing is a pretty common thing for us to do, and no reason in principle why that wouldn't apply here. Particularly, as I say, if the progress of the case to that point has shed some light on some of the issues which were causing concern on the damages on the economic side. So that's kind of it, I guess, at this point in relation to the funding piece. The comment I made at the tail end of my email was just a thought for discussion. So as you know, I think our group has an affiliate insurance arm that does that arranges litigation insurance. It's independent from the URSO business, but there's some overlapping management and interests. And the kind of insurance products that group offers are things like judgment preservation insurance, litigation insurance to deal with fee shifting risks, and contingency fee insurance to enable law firms to share risk with insurers as sort of as an alternative to litigation finance. So I don't know how familiar you are with those types of insurance products. It's something you guys have looked at in the past or have used?
We've looked at it once, it may have been part of this process where somebody came forward with an insurance type proposal. So I wouldn't say we have a lot of experience, but it's not something we've never looked at. Can we table that for a minute? Happy to return to it at the end, but I have some questions just to sort of start the conversation. But the first question is a bottom line one. Do you have approval at the investment committee to proceed at $3 million? Or is this a version of what we had last time where we used in Southern Substance said, well, I think I may be able to do a deal at 5.5.
This is the investment committee has given us essentially conditional approval to do up to 3 million. The conditionality really just being a sensible agreement on how that gets allocated relative to the budget.
Okay, sensible. So let's talk about that. Are you looking for something where we're mandated in some form or fashion to take certain amounts based upon the juncture of the case, or because we would prefer something that's more flexible. So that formulation is something that we should talk about.
I think the answer is the way we would typically fund and what was contemplated under the draft funding agreement that we sent a while back, which I don't know to what extent you engaged on that in substance, but what is normally contemplated is that we fund in accordance with the agreed budget stages, but it's sort of those serve as kind of milestone upper limits on how much we would fund for particular phases in the case. So there's no obligation to draw money you don't need or anything like that. But what it is intended to achieve is that if we agree to a particular
that was timely.
I'll get him back.
right at the punchline.
Yeah.
You couldn't have scripted it better.
Sorry about that. I'm not.
Oh, there he goes.
Sorry. With no explanation, the team just decided it had heard enough from me and it kicked me out.
You were in the middle of explaining, again, just to frame the issue.
The budget allocation.
Yeah, we would like flexibility as to when we draw. Given the nature of these cases, and I'll be candid with you. We are likely going to bring some other firms in to backstop the funding of this case. But it's going to be a situation where the firms we're going to pick, and we haven't figured this out completely yet, although we have a list, both have the wherewithal to fund and give us some capable lawyers, but we'll submit to our lead. We put together this case, and we're going to run it at the end of the day. But we need to be prepared at a $3 million funding commitment. The sensibility we need to have is that we need to be able to fund the case ourselves, and we're going to need some depth to do that. And that can work in conjunction with a modest but helpful funding sort of backstop commitment. But we don't want to be mandated as to when we take. We're going to draw the money, including right up front. We have some expenditures that we'd want to incur, including paying Randy, who's here, for the incredible work he's done to help us get here, and the PR effort, and probably some economic work up front. But we want flexibility in terms of we don't want to be mandated as to when we take money. And after all this back and forth, I want us on the same page. And so that's
when you say you don't want to be mandated, because I think the way in which we always structure our funding agreements is that there is a budget appended to the funding agreement, and we will fund up to the amounts, or we're obliged to fund, I should say, up to the amounts allocated to the relevant budget stages, but we're not obligated to fund over those amounts because, and the reason for doing it that way, and this is an unusual situation, I really recognize that, but I mean, typically if we're funding the whole case and fees and everything, what we want to try and ensure is that the funding agreement is, the funding commitment is deployed in accordance with the budget plan. We don't find ourselves having spent half the funding commitment and we're only in the early stage of the case, because that almost certainly means we're going to be running over budget, or at least we at least want to see that coming and be able to kind of manage accordingly. And so having that kind of milestones-based approach, or stage limits, or whatever you want to call it, is kind of a way of dealing with that. So it's not mandating you to take the money in the sense that you could, you only draw the money if and when you need it. And we're normally fairly broad strokes about stages. So we're not trying to allocate, dollar amounts to kind of individual line items. But for example, if we said, look, the budget said, the spend through motion to dismiss was going to be 500,000, and you submit a drawdown request for $1 million, and you're still pre-motion to dismiss, then at that point we would be saying, well, the funding agreement doesn't oblige us to fund the excess portion. So I guess just want to sort of understand where you're.
I'm addressing sort of the polar opposite concern. I mean, I think we all respect that you don't want to have kind of an overdraw situation at an early juncture, and we 100% understand that would be willing to agree to limits, but the possibility is the opposite. Mm-hmm. Is, let's say we say 500,000 through year one, staged as pre-motion to dismiss work. Well, I'm just throwing out a number. It's probably 250 to 500 is not crazy, and we only take a portion of that, either because of the progress of the case, or, and I'm being very clear about this, we are going to put together some firms, and we are going to have to put some of our own skin in the game to fund the case, given the $3 million commitment. And that we're prepared to make that work, but it could result in junctures of the case where we don't take up to we take less.
Yeah.
And I want to make sure that's okay, depending on where. Yeah.
Yeah, I think short answer is yes, that should be fine, because I think our sensitivity is the exact reverse, as you said. And the facility would be a drawdown facility. So we don't just sort of fund. You have to submit a request to us to say please fund these amounts, and it's in accordance with the stages and what have you. The only thing I would just, again, and we could sort of talk about it in more detail if everything else is starting to line up, but I suppose the only thing I would be sensitive to is, and we actually saw this on Caroline will recall, we had this kind of strange situation on a case just recently which sort of shone more of a spotlight on it. If the intention is to essentially try sort of not use the funding at all, and therefore, and just sort of have it as a kind of fallback option for later on in the case, but where there's some likelihood that you may just not even draw any material sums under the funding agreement at all, then I think we might want to introduce the concept of a minimum utilization that says, well, look, if you've drawn less than X 100,000, by the time the case concludes, you are deemed to have still used a certain minimum amount such that we can still make a return for having allocated the capital to the investment. I mean, it doesn't sound like that's your intention. It sounds like you just, you want to have the freedom to sort of eke the funding out during the life of the case, but still use it, in a sort of traditional fashion. Then I think that's fine. But I think if you're if your intention is sort of you may never need the funding and you just want to kind of keep it as a backstop position, again, we might be okay with that, but I think we would just want some minimum utilization concept to make sure that there is at least some return for us for having committed the capital to the transaction.
Yeah, I'd say we, how would I put it? We want to manage the funding in a way that balances it along with contributions from the different firms, and see whether over time we can actually minimize the extent to which we use the funding if we have other firms in the mix. I don't know whether it's going to play out that way, because we have a list of firms. We have not actually started talking to them to bring them in. But again, James, when we candidly thought this or so thing isn't going to work, we want to do this case, and this gets back to one of your risks, which is, well, can you carry the case if you hit the $3 million funding figure? We're filing this case committed to winning it, and we have to put together a roster of firms that are capable along with us, because at $3 million, we're going to have to put money in to carry the case. That's what we're prepared to do. The $3 million is helpful. We may end up using it. I don't know. But we also may end up saying, you know what, we can carry this. And the terms are borderline acceptable. We argued over them for quite a bit. It was a while ago. It's expensive money. So if we can avoid the money, and we, and maybe we can, maybe we'll need it. I don't know. I just feel like we're entering into a partnership here. I want us to understand each other, so this will work. And I think that's the most candid, explanation I can offer as to where we're at today. Ethan, you want to speak or no? Jim, anything you want to?
Yeah, the only thing that I'll say is that it's highly likely we're going to draw down on it in the pre-motion to dismiss stage. Like, I mean, even if there are firms that come in, I don't see us, not drawing down during that initial period. I don't know, Jeff, if you have any thoughts about that, but I think that is almost certain.
Yeah, and that would include Randy needs to be paid. And that'll be a figure that, forgive me for this, Randy, with you here when I said we probably weren't going to. We're not here to negotiate that amount, because that's something we got to work through with Randy. But it'll be a six-figure sum, on the low six-figure sum, and we're going to do PR, and we want to do PR right. And we want to do some economics, probably up front. I don't know what that's going to come to, but it could be $500,000 in the next year. Ethan, Jim, fair?
Totally fair.
Yep.
Yeah, that's a virtual certainty. It's the overtime stuff. And Jim, what you're hearing me say is, well, if we get all these firms together and we can carry some of this, because we're going to have to, we had a $10 million estimated budget. So sort of at every juncture, we're going to assume 30% could be covered by you and 70% by the firms. But if the firms can cover more than that, maybe we'll do that. I don't know. That's all I'm saying to you.
Okay. It's interesting. It's an interesting. I think it's a logical consequence of, of where we've ended up. So I can kind of completely see that from your perspective. It's an unusual dynamic. Usually the dynamic is the other way around. The funding gets drawn more quickly. The case runs ahead of budget and gets drawn more quickly than people expect, and we're having to retrade and upsize. Having it kind of break the reverse is an unusual idea, and I think we may be okay with what you've proposed if I suppose I'm just thinking aloud really, and I think on one level, I think it's not our primary concern typically in these cases, but I can see at its most extreme at its sort of most extreme iteration, it becomes a bit of an unusual situation where, I mean, if we're kind of essentially all of the out-of-pocket costs through motion to dismiss, maybe kind of the riskiest phase, and then none of the cash from that point forward, once some of the risk of, in the only cases, has fallen away, and at that point, the other firms want to come in and participate, and you don't use our money at all from that point forward. I don't know. I just have to probably think about that briefly. On one view, why should we care? Because if we're willing to fund anyway, pre-motion to dismiss, why does it matter? But I think we do kind of think about the investment in the round, and so, we're not. If all we were ever going to do was do 500,000 of pre-motion to dismiss expenses and nothing else, I don't. That's probably not a terribly attractive investment, given the longevity on it.
And I'm not saying that's necessarily what's going to happen. So it's clear.
One other question for you, just as we think through that piece. So, new firms, would our position be secured against the gross attorney fee recovery for all of the firms, rather than just against, for example, Constantine and Zell? So in other words, the new firms coming in would recognise that our return on investment essentially comes off the top in the fee. Well, not, it doesn't come off. It comes off the top, and then it is subject to the waterfall. But I guess what I could see would be an issue is if there's a dilution effect on our security by virtue of the other firms coming in. I can see that being, that raising issues on our side, given the sensitivities over economics and recovery.
I think we're going to have to think about that and get back to you.
Okay.
My seat of the pants is, your security. My assumption has been the funding would be within this group. The construct, Randy's here because it still would go to WAPU, and we would still have an agreement where whatever goes to WAPU would fund the case, and would essentially fund us and Zell per whatever we choose to take. And I would think off the top of my head that your security interest would be limited to our share of the attorney's fees. And they make it harder for us to bring in other firms. I'm talking out loud, which is a dangerous thing. So Jim and Ethan, you could disagree with me, or we could just take this up offline, to bring in other firms who may not be interested in any kind of funding. In fact, the firms we're looking to bring in are firms who have the pockets to, traditionally self-fund. So they,
I think we need to talk it, because I think the way that fees get distributed is the court orders an amount of fees, and then it's up to lead counsel to distribute it. And the mechanics of all that I find difficult to think through on the fly like this.
Yeah, that makes sense. Maybe take it away and have a think about it. I think just giving you my sense as to, I think if we have to go back and say, oh, good, we're okay to move forward at 3 million, but we will only be secured. If new firms come in down the road, that will have the effect of maybe helping carry the water on the on the unfunded portion of the budget, but it will have the effect of diluting our security, because instead of being secured against the 100% of the attorney fee recovery through the waterfall, we're only secured against half of that. For I've sake, I'm just plucking a figure without any sense as to what your deal would look like with your co-counsel, but you're only secured against half that amount because half of it flows out to the other firms unencumbered. I think it's going to put us right back where we started in terms of folks saying, well, actually, then the economic concerns that we had to begin with crept back in. So I think I'm guessing for us it would need to be secured against the gross attorney fee recovery, and the justification for that being, we've provided early stage capital before any of these other firms even came on board, perhaps. But I think that's kind of my, again, I'm off the cuff as well, but that's my instinctive view as to what I think we'll get told on that concept. But let you take it away and have a think about it and discuss it, and you can let us know what your thoughts are on that.
Okay.
Do you want to talk briefly about the sorry, you maybe had other comments or thoughts on the...
Well, we can talk insurance, but I want to make sure if Jim or Ethan has any questions, or Randy, before we conclude.
I'm good.
Yeah, I'm good. I'm going to have to drop. I have a call at 11. This was my hard stop. Sorry, guys.
Yeah, no worries. I have a stop in a couple of minutes as well, although I can probably just be a couple of minutes.
So Jeff and Ethan, I'll catch up with you afterward.
Okay.
And it doesn't have to be in the middle of your vacation, Jeff.
Okay.
All right, bye.
All right.
Thanks,
bye.
Jim. You on vacation, Jeff?
I am.
Whereabouts?
I am, but I'm on the Gulf Coast.
Oh, nice.
It has been nice, although not so nice today, which helps my mindset as I'm on this call since it's raining at the moment. Any other questions on our end? You could talk about the insurance. None from Ethan, none from Randy.
So the idea on the insurance, you've looked at this already, and I've only got a couple of minutes, but the way it would work, the way I would anticipate, I envisage it working, is so you'd have $3 million of funding from us, which would be the sort of the initial source of funding for the first stages of the case, and then, for the sake of argument, and I'm just plucking a figure, it could be higher or lower, but let's say you bought $3 million of insurance. So what that insurance policy would say is, it would say, if you lose the case, then the insurance policy will reimburse you for up to $3 million of out-of-pocket costs that you have carried in the case unfunded. So it would sort of be back to back. It would sit back to back with the funding commitment, such that you'd spend the $3 million. And then for a further $3 million of expenses that you carry without funding, you would be insured in the event of a loss, in exchange for which there would be, a fairly modest premium to pay up front. We can talk about whether that can be funded from the funding commitment. And then typically some, $1 million or so of a back end premium, payable to the insurer from your, eventual recovery. And it would sit in the, we'd have to work out how it sits in the waterfall relative to the funding return. But the idea of it is, if you don't take any more funding, it becomes more of a cash flow consideration for the firms, because you're not at risk for those $3 million of additional expenses you incur, but you do have to provide the cash flow. The reason for suggesting it as something to think about is twofold. Is really one, maybe it helps bridge the gap a little bit if you're going to have to carry expenses without funding, and maybe the firm is more comfortable doing so if it knows that it can at least recover those from insurance policy if the case is unsuccessful. And when I say unsuccessful, that means any permutation where you don't recover enough to make yourselves whole for those insured expenses. The other thing that was in the back of my mind is this type of insurance can often serve as sort of partial collateral for a source of capital. So, I mean, frankly, if we get to that stage and, we continue to we think the case is progressing well, if we are, you could assign the insurance policy to us and we could just lend against the insurance policy, for example, at that stage. I can guarantee we could do it, but it certainly makes it a lot easier because, essentially we're just lending against, an insurance policy rather than taking, traditional litigation risk there. or if not us, there may be other capital sources that would be willing to do that as well. So, I throw it out there because we've done this before in another case. It's a very different situation. In that instance, the client just took out insurance policy up front because they intended to self-finance, and then after a couple of years of litigation, they decided that they wanted to raise some capital, and they just offered us the insurance policy, and we took an assignment of it, and we funded them on fairly competitive terms to reflect the fact that we had the benefit of the insurance hedge. So, it would require engaging with an insurer to see if we can get terms. But we have insurers that we work with a lot on the judge side. It's usually pretty quick. So I throw it out there as a possibility, as a way of giving you guys something more than just $3 million and you're on your own, without starting from an initial commitment of $6 million of cash, for instance. So anyway, if that's something that you're interested in exploring, I can certainly have one of our colleagues on the insurance side, speak to an insurer and get a non-binding indication of terms, and then you can have a think about whether that makes sense.
So I just have at least one question. So you've thrown out an additional $3 million in insurance that would insure, as I understand it, would insure us for out-of-pocket expenditures that we're making.
Mm-hmm.
So the insurance policy would cover that if we don't recover that amount.
Exactly.
The additional $3 million, is that a considered number, or is that just a discussion number?
Yeah,
I just threw
it out there. Could potentially be more, could be less. Yeah. I just threw that out there illustratively.
We can talk about it. I kind of want to keep these separate for the time being, because this is complicated enough.
Mm-hmm. Yeah.
We have a discussion in terms of the $3 million being secured against the entirety of the attorney's fee award, as opposed to our portion of it. And we hear you on that. And I put to you sort of how we're looking at, we're almost certainly going to take a chunk of money up front, and we may end up taking up to the full $3 million over the life of the case.
Mm-hmm.
But we want flexibility around, I think we're okay with junctures and caps within those junctures.
Yep.
And an understanding that we may take less than those caps based upon the need of the case and our own situation. So you need to think about that too. Maybe we reconvene. I'm back next week. Let me ask you this question. Randy is here, and Randy is poised to resume recruiting class reps. We started that process and we stopped it. We did exactly what I didn't want to do, which was start talking to families and have a start and stop. And I regret that. It's just not fair to people. So we would like Randy to resume what he's doing. But I don't want him to do that unless we have realistic certainty this is going to happen. So let's say we speak next week and we're satisfied. There's a question to you and there's a question to us, and then we walk away with, okay, we have a deal. You have an investment committee approval. How long till this deal can be closed? From that moment.
I think very quick from our side. I mean, we sent you a draft funding agreement. We'll need your comments, if anything, on that. We will probably need. In terms of like signing on the funding agreement. I mean, that once that's fully negotiated, a couple of days to get ducks in a row to sign, and then usually, I mean, we can fund at closing. if everything's ready to go, or process a drawdown request post closing, and takes us a few days or whatever to process a drawdown request. So I mean, I really don't think. I think if we can resolve this sort of the allocation, budget allocation point / minimum utilization, the extent to which we're secured, then I just don't see any reason for it to take week or two just to button everything up, depending on how to what extent there are issues on the funding agreement. I mean, if obviously if we go into a lot of back and forth red line on the funding agreement, that can take some time, but I mean that's within our collective gift to control. But other than that, I really don't see us needing much time at all, just to sort of do the administrative stuff.
Okay. That's good. That's it for me.
Okay, great. Well, I'm going to hop onto my next call. I'm late for, but this has been helpful. And on the insurance thing, there is no reason that it can't be done sequentially. So I mean, if there's a pathway for us to get comfortable and get this done at 3 million, we can, to the extent that you want to pick up the insurance discussion, maybe in conjunction with your discussions with co-counsel, or maybe helps folks, or maybe they're not interested in it. We can do it that way around as well. It was more, I just threw it out there as a way of an idea that would, might help bridge the gap if you were just looking at this, in terms of the existing firms carrying the water.
Yeah, I appreciate that. It may prove helpful. I'm not saying this is not something that may not prove to be of interest to us or maybe to others. Maybe it'll help us with other firms. So it's good to know.
Okay.
And we may even say, show us what it would look like.
Yeah.
The economics. But we should talk about it first.
Yeah, no problem. Well, I would just throw it over to our colleagues on the judge side. I think they probably, maybe a week to get an indication of terms from carriers. So maybe just sort of think about it, bear that in mind if you want the lead in time. Great. All right. Well, thank you all.
All right, everybody. Good chatting.
Yeah.
All right.
We'll catch up next week. All right. Thanks.
Bye.
Bye.